the will. That at least tells the court who gets your stuff when you die and who manages your estate, who's the executor, right? If you got nothing else, I would at least do a will. The con here is, and the common misconception is, if you have a will, you're probably still going to probate court. It does not avoid court. It just tells the court who gets your stuff, so you're in control of it. If you do not have a will and you die with no estate plan, then the court has to look at what's called the intestate succession statutes. Those are the statutes that tell the court who gets your stuff when you die if you haven't told the court by will or by trust. This is very, very common, frankly. We do a lot of probate, and a lot of times it's intestate because, of course, people don't want to think about what happens when they die. And to give you an idea, if someone passes, they have a spouse, then of course the community properties go into the spouse. We're a community property state, 100% going to the spouse. Separate property, this person is going to go half spouse, half child if you have one child. If you have multiple children, then it's going a third spouse, 2/3 kids, no matter how many kids you have. If you pass away and you don't have a spouse, but you have children, of course they will equally inherit. If you pass away, no kids, no spouse, it's going to the parents, either both if they're alive or one. Then siblings, then nieces, then remote heirs. And then ultimately, if the court can't find any blood relatives, then it goes to the state of Nevada.